I'm Gary Venner, CEO of IFA Acquisitions, and I'm joined by Anand Chandarana, Senior Tax Manager of Haines Watts, who are one of the top 15 chartered accountancy firms in the UK with over 50 local offices, where we continue our informative question and answer series on our YouTube channel to provide insights into helping buyers and sellers understand the benefits of using brokers for the purchase and sale of IFA businesses, and also from using accountants for sound tax planning advice. The title of the next video is coming up on the screen now.
So Gary, on the acquirer side, what are the commercial risks they're looking for, and specifically, is there anything in relation to, say, the culture of the target company that's relevant that they should be considering?
Absolutely. So any acquirer really needs to understand what is the real risk and what's reputational risk, I think, that they consider. So if we take real risk, share purchase, they need to be happy that they are taking over the liabilities of that company, and including past advice. Whereas, of course, on an asset purchase, that risk stays with the original company, and that is not taken over, is a real risk. What you can consider, though, is there could be a reputational risk. So, an acquirer does not want to know that it's the clients that it acquired are having issues that may get into the press, etc., over bad advice from the previous entity. However, that's all part of the due diligence, being happy that this business was well run and that the advice was sound. And DB pension transfers are a concern, but I would say it's much more of a concern for those businesses that made it their business to focus on that element of business, and often almost to the point where they were doing transfers for everyone. For some businesses that's not going to be the case, and they followed really sound gold standard of practice. So good acquirers will also know that that was good business too. So it won't have the same concern, but will need to do extra due diligence to make sure that they really did follow that sort of standard. When it comes to looking at risk, there are aspects, commercial risks, that you need to really sort of consider there. And first of all is, will the clients walk or will the client stay? How good was the relationship between the advisors and those clients? So it's really important that, again, that I'd say the culture, the ethics, the client values are very much aligned, because if those clients are going to have a similar style business look after them, they're more likely to stay and to be retained. Other risks to consider will be, of course, in terms of the business owner coming back into the market as well, and those clients, solicitation's really difficult to prove sometimes, and so it's really important to know that that you feel quite comfortable that what you're buying will stay with you and won't walk. And the same with advisors as well, that if advisors are coming to join the business, and particularly where the relationships have been built with those advisors, that even under a non-compete clause, that clients won't follow there as well. So there are those aspects that you would say you need to really sort of be aware of, as well as the risk of investment and the alignment with your centralised investment proposition.
Okay, excellent. One of the aspects we touched on earlier was about liabilities. So can you just give me a bit more detail about that, as to how far an acquirer's liability might go into the vendor's business?
Yeah, sure. So liability, particularly, again, we're looking more at share purchases in this situation, but the entity that you're buying, whatever transacted before, is potential liability for future claims. If we look at client claims, then the Ombudsman will typically say up to 6 years from when the problem arose. Now, you may feel that, well, the problem arose when the advice was given, but it may be that a client wasn't aware of the problem until later. So that 6 years actually starts from when the problem arose. So it's always worth bearing in mind that can be longer than you possibly think. But that's why you have professional indemnity, and that's why you have due diligence, to make sure that you're happy that the advice is sound. And I would say again, vanilla businesses are great businesses to sell in that situation. Contract law, as you know, sort of the 6, 12 years, etc. But equally, I would say the biggest area, I suppose, would be HMRC. And you're an accountant, so you're better than me to answer this. But my understanding is, you can expect from sort of innocent errors, sort of 4 years going back, if there was, not completed, sort of 6 years. But also bear in mind that if it was felt that the HMRC, so it was a deliberate act, then it can go back as far as, say, 20 years.
Absolutely.
So, it's always bearing that in mind. I do feel, though, that a lot of sellers that are happy to get behind and put warranties in place, because they know that their business has been well run, and there's nothing that really concerns them on both of these. So there are aspects that they will sit behind it for a limited period.
Sure.
I say nobody wants an open-ended personal guarantee, to the grave. So having limited a period, and often we see in contracts that may be anywhere between 3 to 6 years for previous advice, and it can be say up to 7 years for HMRC, and most vendors will get behind that.
When you often, as you sometimes have, you'll have a business that's got essentially what non-trading assets or non-core trading assets, and the acquirer is not particularly interested in buying those. So what would you normally say to your vendor about those assets? For example, company cars. And actually, I suppose you tell me, but I imagine there'll be some acquirers that actually don't want the staff necessarily to join; they just want the client bank.
Exactly. Well, if we start with that an acquirer only wants to acquire the clients, then that's probably going to be an asset purchase in that situation. And if that's the case, then the vendor will be responsible for all the other assets in the business. So company cars, I would be imagining at that point there's no advisors, no company cars for other employees, so they would tend to be relating to the owners of that business. So they're more likely to retain them for their personal use, or change the leasing arrangements into their personal names, etc. In terms of other assets, and it will be to liquidate them, really. Of course, if it's part of the share purchase, then the acquirer will be responsible for those assets and will take them over. They will take the ownership, and they'll take any leasing loan agreements that are attached to them as well. And if they're not happy with them, then they'll presumably be expecting the vendor to liquidate those assets prior to the sale. So on completion date, they're no longer in the business.
That was one of the questions I was going to ask. Is that one of the areas you would advise vendors to look into if they're thinking about sale, and potentially tidying up the business from removing personal assets as early as possible?
Well, it's not a big issue, I've got to say, and normally I think it goes with the territory that if somebody is selling just their client bank, there's an expectation of what they need to do in terms of those other assets, and not forgetting that it may be a limited company, and of course with the deferred payments, that company is likely to still stay open
Yes.
for the next couple of years, and therefore, those transactions can still go through that limited company in any case.
Excellent, thank you. So Gary, I assume in a lot of the businesses that you see, they'll have trading premises and staff, of course, that they're required in running their business. What happens if the acquirer is not interested in acquiring either of those assets? If you like?
So if we look at the trading premises, then it will be very much about whether the acquirer wants to continue to have an office in that location, and many do. So it's suitable for those acquirers probably to retain those leased premises, or probably happier on leased premises than they are to actually spend out on a freehold, which can be quite a sizable investment in itself. But if we look at leases, they can vary massively. Some may just have a notice to quit, which is 1 month, 3 months, or there may be the terms of that lease. What is important is, again, whether this is a share purchase or an asset purchase. A share purchase, then that lease will come with the deal. So it's really important to look then at the legal warranties in that contract, particularly under dilapidations, I would say is a concern, and how long you would have to a notice to quit as well. So those are important. But frequently we find that the premises of an IFA's business is actually owned by the IFA, or more normally within their SIP. And frequently an acquirer, even under an asset purchase, may then come to a new agreement with the vendor's SIP to take on a lease over those premises. It does give continuity in terms of the business is still going to stay there. Clearly, if the acquirer already has an office just down the road or can centralise various functions, then it doesn't really need to come with it. And in that situation, the vendor will just put the property on the open market and let it elsewhere. Staff, again, it's really important to know whether the acquirer is going to be taking on the staff of that business or not. And this is an area really which needs to have expert legal advice, or to look at an HR specialist, particularly with TUPE. So a share purchase, you're automatically going to be taking over all of the staff contracts. And again, for a seller, it's really important that they understand the pitfalls, particularly if an acquirer says, well, I don't want this staff or that staff, because if it can be proven that it relates to the transfer, then there could be an unfair dismissal claim. So again, really important to take expert advice. And I know, for instance, at Haines Watts, you have that department as well that can look at it, and we're coming up with another video series actually with HR people support, which will cover those areas, particularly around what happens with staff contracts, because it's really important again to know that under TUPE, those employees must not be put at a worse situation where they're in now. So you have to take over those contracts, the pay, the benefits, the holiday entitlement, and of course if you are taking those staff on, you also need to be aware that if in the future you do look at making some of the staff redundant, they will have protected rights over the number of years that they have already accrued, which you take over. And I think that's fair. The staff should be well looked after, but it's areas that you do need to have the right advice.
And that is absolutely something that illustrates how complicated even the most simple business might be to sell, because there's all these various aspects. There's the legalities in terms of focusing on what the trade and assets side of things, but actually ultimately there are individuals there, and it's very important that they are considered in any sale process. And I think a lot of these vendors that you deal with, potentially these sole trader ones, that's how they've grown their business, is using these they're hiring valuable staff and keeping them engaged in the business, and they will be interested in making sure that they're looked after, as you say. So it's a very important area not to be missed, I would say.
Absolutely, and let's not forget that we do have a lot of sole trader businesses or sole advisor businesses that automatically know that their personal assistant, paraplanner stroke administrator will look to retire at the same time as them, and they will consider a redundancy package before, and that's normally because it's only going to be an asset purchase, etc. So again, as long as everybody takes the right advice and consultation process is put in place, then these things can normally be easily looked after and to the satisfaction of all concerned.
That's great, thank you.
Make sure that you subscribe to our YouTube channel and switch on notifications so that you won't miss our next video in this series. We provide insight into the tax planning benefits for an exit or acquisition of financial advisory businesses, as well as the benefits of using brokers by two industry experts, me, Gary Venner, CEO of one of the UK's largest specialist brokers in IFA Acquisitions, and Anand Chandarana, Senior Tax Manager of Haines Watts, one of the UK's top 15 chartered accountancy firms.